Good morning, everyone. I'm Joanne Koontz. I am here with my partner, Jackie Durham, once again. We are here today. It is October 27th. We have some tricks and treats for your Halloween pleasure. We're going to talk to you today about documentary stamp taxes and what they are and why they're constantly an issue that people don't anticipate. So when we see this, we are typically in the middle of either a real estate transaction or somebody trying to do a real estate transaction on their own. And we sometimes clean up the bodies after that mayhem. So Jackie has a front row seat to this as always. So we'll explore some of that, some of those issues, what we see come up and misconceptions that we typically see. As always, you are welcome to submit the Q&A bar at the bottom. You're welcome to submit questions. As we go, we will answer those for you. As always, our sessions are always recorded. They'll be distributed to you on our Facebook pages, on the Koontz Associates and Koontz Parkin websites, and also on our YouTube pages. So you'll have plenty of opportunity to get back to this riveting information at your leisure, right?
Right.
Thanks, Jackie, for taking time out of yet another busy day to cover such a fun topic. One of the things that I field phone calls that I field on a regular basis is where someone will just call and say, I need a quitclaim deed. How much is it? And how quickly can you get it done? And I'm always like, whoa, we have 20 questions we need to ask ahead of time. And oftentimes there are concerns that weren't even rolling around in the forefront of that person's mind. So that's typically how the conversation starts for me. I don't know if you see anything different, Jack.
I like it better when they come to us first, instead of us finding the issue after the fact, after the documents have been executed. But yeah, I definitely think that folks don't necessarily appreciate the applicability of doc stamps. Number one, if you're coming from out of state, you likely have not heard of documentary stamp tax. And what it essentially is an excise tax that is taxable on certain documents that are delivered, executed, or recorded in the state of Florida. So it's in lieu of essentially a state sales tax. So this is how the state of Florida generates their income. They like to boast about how we have no income tax, but we do have doc stamps, which is something a lot of people don't hear about. Mm-hmm. And many times I feel like in a traditional real estate transaction where we have realtors involved and a formal closing agent, you see a line item called doc stamps on your closing statement, but it's among 50 other line items and you don't pay a lot of attention to it. So it's not always something that, especially if depending on who you're closing with, it's not necessarily something that's going to be explained to you. So when you're going to transfer an interest in real estate, whether it's by way of a quitclaim deed, an easement, a contract for deed, and even in certain circumstances, an assignment of lease can trigger doc stamps. You really have to take a close look at really any kind of transaction that involves the transfer of an interest in real estate directly or indirectly. You need to really take a close look at the particular facts and circumstances involved, because very likely you could be triggering doc stamps. Mm-hmm. Doc stamps not only come into play with quitclaim deeds and easements and those direct transfers of real estate, but they can also come into play if you're transferring an interest in an entity, which we'll dive into that in a second. And then in addition to the transfers of interest in real estate, doc stamps come into play when there is a written obligation of repayment that is remitted or a lien that is filed against real or personal property. So
now, let me
it
stop
extends.
You there. Written obligation of repayment is a fancy way of saying a loan.
Right. But yeah, but what I do also want to say is a lot of, I've noticed, especially recently, for some reason, I haven't started noticing this until now, but a lot of folks try to bake in repayment terms into a separate document like a contract or even an exhibit to a contract. Those are still written obligations of payment. So just because it's not under a fancy promissory note or just because it's on a napkin doesn't mean that it is not subject to doc stamps. So I've kind of tried to warn clients about that because that's overlooked many times, because most people think of promissory note or lien or something like that triggering doc stamps, but it's any written obligation of payment. So
And let me just clarify that there's doc stamps on the transfer of the property, so like on the sale, and then there's doc stamps on any lending. So even if you're just refinancing, you're going to pay those documentary stamp taxes again. And that's oftentimes why people, particularly from out of state, will go, oh man, your closing costs are high. Well, it's because, like you said, there's no income tax, and this is how the state generates their revenue. And although your title insurance is rebated and there's a reissue credit when you refinance, the doc stamps you pay all over again. So you do need to be mindful of that when you are getting into a lending situation, particularly something that you might consider short term, because you're going to repay. Sometimes people will say, oh, I'll just do this now and then I'll fix it later. Well, but do you understand the cost of doing so?
Right. So one of the, basically the doc stamps, just to quickly outline what those look like, it's a tax. If it's a transfer of an interest in real estate, it's going to be 70 cents per $100 of the consideration. And what we can tell you, yes. So the consideration is a fancy word for saying the sales price. So the cash you're handing to the person who's giving you the property. Or if you're exchanging properties, if you and your neighbor decide that you like each other's properties better and you say, we're just going to swap, the consideration is going to be deemed to be the fair market value of those respective properties. The consideration can also be if you are, say, contributing property to an entity as a capital contribution. The consideration there is going to be the fair market value of the property. Even though you're not paying the company anything, you're contributing that property to the company, that's going to be considered the consideration. Or if you have a company in which you receive a distribution or a dividend in the form of real property in lieu of a cash dividend or distribution, that's going to be considered the consideration. And most importantly, this is the big hiccup we run into that a lot of people are unaware of. You know, it's typically folks who get a quitclaim deed offline, they transfer their property to their brother, and don't realize that even though no money is changing hands, an outstanding mortgage on the property is going to be deemed the consideration for a transfer because there's basically a change in the assumption of that obligation. So those are all, those all fall under what is considered to be consideration. So it doesn't have to just be cold hard cash. It can be different forms of consideration that can trigger the assessment of that tax.
And you're spot on when people try to do it themselves, or even when they call here. I had one not too long ago, somebody called to get a quote. How much is a quitclaim deed? I told them, and then said, hey, we have all these other considerations to talk about. And they said, man, you're the most expensive lawyer I've talked to. And I was like, well, the doc stamps don't go to me. If so, I would really love to do quitclaim deeds all the time. But, you know, not everybody is advising folks about that. So the person that I had spoken to was very surprised to hear about this. And it was in the neighborhood of $2,000 because of an outstanding mortgage. And that doesn't matter if you can say, there's no consideration, that mortgage, there's no way around that. So we have to be, if you don't do the doc stamps, you're just going to get a love note from the Department of Revenue in about 3 years that says, hey, you forgot to pay me 3 years ago. So plus penalty and interest, now it's much more. But John Elslander is very busy over there finding all the doc stamps that were not paid. And he goes, I don't think so. Without the proper recitation on the top of the quitclaim deed to advise why you're paying the minimum documentary stamp tax of 70 cents, you're going to get a love note that says, I think that maybe you should have paid more.
Yeah, and don't think that the Department of Revenue is not going to come hunting for their lunch money, because they are. And they scour the public records. They look for deeds where there have been no doc stamps paid, and that's automatically a red flag for them. And they will look into things like this. So it's
and it's really literally important. A job. There are literally people there that's their job all day, is to comb the public records. They're not doing that part-time. They're doing that all day, every day, to find those minimum doc stamps deeds.
Right.
That's their job all day.
And don't you think, Joanne, also that there tend to be a lot of third parties that offer indirectly legal advice when it comes to these situations? For instance, lenders who say, hey, you can just transfer the property to your entity after closing. Don't worry about it. Let's just go ahead and get this loan closed before the end of the month. And
Yes,
that
and I have had to be the bad news bearer just recently on one that was a commercial transaction, and it was in excess of $1 million. So unfortunately, I got these people too late in the game to help them to stop that. But essentially, what I was like, okay, that's fine. You should just find a lender who can loan to the LLC. There's plenty of them. Plenty of lenders in this environment are able to handle a loan to an LLC if you've got a rental property or a commercial property or something like that. If you instead take title in your name and then transfer to the LLC after the closing because of the restrictions of the lender, you're then going to repay all of those documentary stamp taxes that you just paid. Never mind that you might disrupt your title insurance, which is a different bailiwick than today. But those doc stamps, like Jackie said, are 70 cents per $100. On $1 million transaction, it was in excess of $7,000. And they were mad. It added to the, if you're doing a business deal, this rental property has to come in at these numbers in order for it to make sense. $7,000 is a pretty big swing. And, it's not always seven, but in that one example, it was over $1 million. And so it was over $7,000 and the people were mad. And they're like, why didn't the lender tell me? Why didn't my realtor tell me? So if you are a realtor, it's not your job. This is not your job to run this. But the more you can provide information to your buyer and say, hey, you might want to talk to somebody about that besides the lender, because there might be some cost that you're not expecting. They'll be grateful for the heads up, because with time, this can all be done properly. But the people that I talked to with the $1 million example, they were about a week out from closing. So they called me like, hey, we need this LLC so we can transfer right after closing. And I was like, whoa, why are we not just closing in the right way? And there was not enough time to start over with a new lender and not be in breach of contract. So they had to do it. And they just were very upset with the lender and with their agent. And it's really not the realtor's problem, but it is a value-added service that you can provide if you are a realtor to have a heads up about these things with folks.
Right. Or to guide them to the right attorney, so that they can conduct this analysis, because it really needs to be on a case-by-case basis. To what extent doc stamps were applied. But as a rule of thumb, I typically, no matter what, I will crack back open the administrative code and the statutes to double check. I mean, I've looked at these provisions more times than I can count, but I still have to go back, because the way they apply to a particular situation is going to be different than the way they apply to the situation I see in the next week. So it's not simple. It seems simple, but it's really not as simple as it seems, and you have to take a close look. Another kind of transaction that a lot of people are surprised by is the assignment of leases. So if you have a leasehold interest that you're assigning for any kind of consideration, which I believe that to even be like, if you have a lease where the landlord says you have to pay me a $2,000 fee in order for me to honor any kind of assignment of lease, that's consideration. Or if you really just want to assume Bob's lease because it's a great space and it's perfect for you, and you're willing to pay Bob $10,000 for him to assign that lease interest to you, that is consideration. And in addition, if the leasehold interest itself is subject to any kind of lien interest, that is going to be considered the consideration. So if you are a business owner and you lease your space, which a lot of business owners do, and you end up transferring the leasehold interest or subleasing the leasehold interest to another person or entity, if you have a business loan and part of that business loan is secured by lien interest against your lease, that is going to also trigger the doc stamps. So these are really common little potholes that people stumble into very unknowingly, because you don't hear a lot about this. But it's definitely something that, again, you need to take a look at. And there are certain exemptions for the transfer of interest in real estate. If you have a gift of real property that isn't encumbered by a mortgage, that is exempt from doc stamps. There's certain transactions between a husband and wife, but I do feel that a lot of folks assume that it applies to all transactions between husbands and wives, and that's not the case. Number one, it can't be encumbered by a mortgage, and number two, the only exception to that is if it's pursuant to a divorce decree. Then even if it's encumbered by a mortgage, the transfer of the interest won't be subject to doc stamps, but that only pertains to the marital home, not to investment properties, not to second vacation homes.
That's exactly where I was going. Took the words right out of my mouth.
Sorry. And you know, the other one that a lot of people stumble into, and that can cause a lot of problems, is the transfer of an ownership interest in a real estate holding company. So Florida statutes established some years back what is referred to as a conduit entity. And essentially what that is an entity which receives real estate or an interest in real estate for less than full consideration. And so what this would look like is, I'm Jackie Durham, and I create Jackie Durham LLC to hold real estate, and I transfer my wholly owned property to my wholly owned LLC. That would not be subject to documentary stamp tax because there is no change in beneficial ownership interest, and my real estate was not encumbered by a mortgage. So having established that, it's important to note that the fact that full consideration was not paid for that real estate transfer, that now Jackie Durham LLC is going to be considered a conduit entity. So if you're a conduit entity and you sell any portion of the ownership interest in your entity within the 3-year period that follows the transfer of the real estate into the entity, that is going to be subject to documentary stamp tax. So if 2 years after transferring the property into Jackie Durham LLC, I decided to sell 50% of my company to Joanne, that is going to trigger the doc stamps. So it's really important to make sure that if you're buying an interest in an LLC, or if you're selling an interest in an LLC or a corporation, and it holds any kind of real estate interest, that you take a close look at that. And I'll also mention that the definition of a conduit entity is an entity that receives real estate for less than the full fair market value of the property that would otherwise be paid in an arm's length transaction with a third party. So conceivably, my example dealt with a transfer from me to my wholly owned entity, but this could also apply to a transfer from me to an entity owned by myself and a few other individuals, in which case some consideration is being paid. We're paying doc stamps on part of what would be full consideration, but we're not technically paying full consideration. So even in that circumstance, even though some doc stamps are being remitted with respect to that transfer, doc stamps aren't being remitted on the full consideration. So that would still technically create a conduit entity, and it still would create a taxable obligation if an ownership interest in the entity was transferred within the 3-year period after that. So I'm not going to dive too deep. We're going to kind of, we're not going to get too technical today, but I do want to mention that these are the kinds of considerations and analysis that have to come with any kind of transfer like this. So
absolutely. And you know, it's the kind of thing that I think just doesn't land. People are worried about, well, I've got to get the property out of mom's name before she really needs the nursing home in 5 years. And so that's what they're worried about. And they're not thinking about all of these other potential issues, whether it's stock or just the property itself. It's the people get laser focused on what they believe the outcome needs to be. And a quick discussion about what your objective is will oftentimes allow us to get you there more efficiently, more cost effectively, with less roadblocks. And like anything else, the earlier we know, the more helpful we can be. And oftentimes the cheaper the solution is, because we're not backtracking and fixing something that's now ugly. And the problem is, I have also seen this where people go, oh, I'm going to transfer it to mom. And then I'm like, oh my gosh, but gift tax and this and that. And you have all these other problems, and you've upended homestead and you've upended title insurance. And they go, oh, okay, well, I'll just transfer it back. No, now we have double the problem. Like, you can't undo a transaction by transferring it back and avoid doc stamps the second time. That's not going to work. That doesn't happen. So now when you go to fix your own problem that you created, you've doubled the problem. So that's it. If you think you're in a hole, stop digging. That's the first, this is the first thing to do. And it happens all the time. And people go, oh my gosh, that was so dumb. I shouldn't have done that. It's not dumb. You didn't know. There's no way Joe on the street is going to know this stuff. We deal with it every day. And as Jackie just said, we still, when someone calls me and says, hey, I'm like, okay, well, let me put the rule in front of my face with your thought path, with your fact pattern in my head. Because still, even though you know this stuff off the top of your head after all these years, you think, oh, that fact might turn, let me see, does it help me? Can I find something in here to use for interpretation that can be helpful for the case? So, you know, don't beat yourself up, but also don't walk in the fire. It's pretty easy.
Well, it's the same reason why we, you know, we are legal professionals, but that doesn't mean that we're going to diagnose every legal question.
Yeah.
You don't know what you don't know, and you need to stay in your lane. So if I have a complicated land use question, I'm certainly not going to try to answer that question. I'm going to deliver that question to somebody who's more equipped to answer the question. And that's exactly why people need to hire accounting professionals, legal professionals, doctors. You know, there are people that specialize in certain areas for a reason. So, you know, it's nothing to beat yourself up over. You're not going to know everything, and that's okay. So.
And another problem that has come up in my closing experiences, we had a situation not that long ago. I wanted to say 6 months ago, but it was before COVID. So COVID is now like the new baby. Like, was that before the baby or after the baby? Like, now is it before COVID? I'm lying. It was more than 6 months ago. But we had a closing where we pulled title. We were preparing for closing, and a couple had divorced. They did their own quitclaim deed as a result of their divorce. Quitclaim deeds look super easy on their face, and they are not. So to know what to put on them is difficult. So nonetheless, there were deficiencies in the quitclaim deed from the ex-wife to the husband. Now the husband is selling to my buyer. I pull title and I'm like, hey, we got to go back to her because she didn't sign the deed properly. So it wasn't effective. So she's technically still an owner. And now guess what? You may have an issue with doc stamps. It's no longer the marital home. It, you know, it was then, but it's not now. So the cost of this, she ended up being unwilling to sign without a little encouragement to the tune of $5,000. So this problem mushroomed on this poor guy, and all he was trying to do was get her out of his hair. So like I said, the fix does not necessarily erase the first doc stamps problem. It can actually cause you to have a double doc stamps problem.
Exactly.
It's bad enough if you get into trouble, but then get help to get out of trouble because you can make it a lot worse. And the other thing that happens is people will go, well, that was a long time ago and I haven't heard anything. They don't come after you 2 weeks later. That could be 3 years later that you're getting the love note from the Department of Revenue. It's like, hey, remember that transaction? Yeah, we want our money. And
well, and the longer you're waiting for that love letter, the higher the penalties and interest become. So those can be hefty. So you know, if you do know that you have made some kind of mistake, and you want to correct that mistake, the sooner you correct it, I guess it's your appetite for risk. Do you want to wait and hope that they don't catch you, or do you want to, you know, pay a little bit extra to make sure it's taken care of and corrected now? You know, that's going to be a case-by-case examination as well. But definitely one you should discuss with your attorney to be safe. And I know that we also have a lot of transactions involving seller financing and just loan transactions in general on the real estate and business side. And a lot of folks will, you know, sometimes come to me after the fact. I'll see a contract that has basically been closed already, and they don't have separate standalone loan documents, but there are payment terms baked into the contract itself, and no doc stamps were paid at the time of closing. So it's important to note that whether it's a lien that's being filed, or whether it's a promissory note or any other written obligation to repay someone, that's going to be subject to documentary stamp tax of 35 cents per $100 of the obligation. And something else to keep in mind is, even if you execute and deliver, say, a promissory note or other written obligation outside of the state of Florida, if that is secured by real property or personal property in the state of Florida, that is still going to be subject to doc stamps. And there is a little bit of a reprieve if you have an unsecured obligation. There's a cap of $2,450, I think it is, on the doc stamps for an unsecured promissory note or written obligation. But keep in mind, if you later secure that with a lien of some kind, now your doc stamps are going to jump up to whatever would have been paid in excess of that $2,450. So it's really important to make sure you're paying attention to those things, because they're like installment sales, and I see them in exhibits to contracts, and people, you know, really don't think of doc stamps when they think of these simple unsecured promissory notes, and they're typically involved in small transactions and sometimes transactions between individuals who are not represented by counsel. And likewise, the discharge of an obligation, which we also can assist clients with, the termination of a promissory note or release of a promissory note or mortgage or lien interest, that also triggers doc stamps. So if you're forgiving debt of some kind, that's going to trigger doc stamps. So I feel like I want to definitely hammer that into everyone's heads, because I don't want to crush the fun, but I can't tell you how many times I've seen people have these private loan transactions and are completely unaware of the doc stamp obligation, and that can of course lead to expense down the road. So.
Well, and you know, when you mention the unsecured loans, that brings up another misconception where I hear people say, oh, we'll just go out on a boat 2 miles offshore and doc stamps disappear. You know, yes, if it's unsecured and you're not executing that note in Florida, but not if you have security. So you can't take your mortgage out to the middle of the Gulf. You've still, once there's a mortgage, it doesn't matter where you physically execute it. So don't let that get you excited.
And make
sure. I mean, the boat ride's
great.
great. Don't get me wrong. Take me.
Yeah. Well, and make sure it's delivered outside of the state of Florida as well. So if you execute it in Georgia and you come and you hand it to the lender in Florida, there's your delivery. That's going to also trigger the stamps. So
fun crusher.
It rarely, when you try to get creative with these solutions, does it turn out well. It typically does not end well. So
I always tell people, someone else already thought of that. You know, you're not that unique in your ideas, so no, it doesn't work. And if it did, there would be strategies about it. So if not, there's case law about it.
Right.
None of it ends well.
So, well, I hope we've sufficiently frightened everyone.
Yeah.
You know, these
seems
really
like such an innocent topic.
Yeah, there's just so many different ways they can get triggered that I really feel like don't worry about it too much. Just run it by your attorney. Take 5 minutes to send an email, and just make sure that it doesn't apply to you. Yeah. And you can safely assume if there's a loan involved of any kind, or whether you call it a loan or it falls under a promissory note, any kind of loan, or any kind of transfer of an interest, direct or indirect, in real estate, it's going to likely trigger doc stamps. So just take the time to cover yourself and make sure you're getting good advice.
We do have a question from Kim. She says, if the Department of Revenue doesn't catch you and you sell to someone else, can they come back on you after the sale, and or can they come back to the new owner?
They can come back to you. I don't believe they can come back to the new owner, because the owner is taking title without knowledge.
Then that's it's a personal obligation. You, the transferor, you, the borrower, have that obligation, because there may or may not even be a property involved necessarily when it comes to generating a liability. So they don't, they don't have to go after that. So, but yeah, they'll be to see you for sure.
Yeah, they will not lose your number.
That's absolutely true. All right. Well, I think we've, beat that to death enough. We will, believe it or not, we'll be with you next Tuesday on Election Day. So if you're tired of that, you can come talk about partnerships and S-corps. It's got to be better than political talk. I also wanted to let everyone know that we will be releasing the balance of our 2020 webinar schedule in the next couple of days. So keep an eye out in your email and on our Facebook page. So that will be coming your way, so you can plan. We're gonna have some Tuesdays that we're off, as Thanksgiving rolls around and things like that, so that you are mindful of the schedule and the topics. You'll have that available. As always, if you'd like to provide us with your input, your thoughts, your feedback on topics you'd like to hear about, we want to deliver what's relevant to you. We appreciate your attendance, and we love helping the business owners and realtors and referral partners in our community. We hope that this is a benefit to not only our clients, but to the friends of our clients and to the businesses that are in our awesome community. So we want to help keep them up and running. We know this year's been nuts, and we hope this has helped. So thanks, Jackie, for your time. Thanks, everyone, for attending, and we'll see you next Tuesday.
Have a good week.
Bye.